In this session, we'll look at a couple of examples to understand the concepts we had discussed about patents in the last few sessions.
So I'll give you a minute to read this. So I'd like to know from you whether IndiVac would be liable for infringing X's patent in India or not. Does X have a patent in India? It's still pending. So will IndiVac be liable for infringing that patent if the patent is still pending? The straightforward answer is no. I told you earlier that a patent will be valid only in the country where it is granted. And until it is granted, you cannot sue for patent infringement. And therefore, because the patent is still pending, IndiVac will not be liable to X. Okay, let's look at another example. So if you look at the next example, there's a person by the name Z or Z who is a HR manager in a company that is into electric vehicles. And this person has worked with some of our friends in a research group and has come up with a biofuel of sorts. Now, the simple question is whether this biofuel belongs to her company or only to her and her friends. So tomorrow you may encounter these problems, right? As employees and senior people, or some of your employees, or you as an employee may come up or face such a problem. So what would your answer be? So the simple question you have to ask is whether whatever she did, has she done it in the course of employment or not? Here in this particular case, the answer is no, and therefore it doesn't. TELSA, in fact, it's not. I just played around with letters there, but anyway, TELSA will not get those rights. However, if you tomorrow when you sign employment agreements, you will notice 3 types of clauses. In fact, it's important for you to just check out what type of clause you are signing when you get these offers and start signing and joining companies. There will be one type of clause which will say that all IP you create, irrespective of whether it is related to your work or unrelated to your work, will belong to the company. It doesn't matter whether you do it while you were in the company or you do it at your own time, right? This is a very broad clause. Now, these clauses can generally be challenged, but a lot of companies actually sign these clauses. Then there'll be another set at the other extreme, which will say your responsibilities to the company are only limited to your specific job description. Anything you do beyond that, we don't really care, right? That IP will belong to you. But if you do something as part of your job description, that will belong to us. And there will be clauses somewhere in between, which will say that if you do something which is related to what we are doing, though you do it at your own time, though you may not use the company's resources, we will still have to own it because we are paying you a salary. And though you're doing this at your own time, and though your job does not describe this, you still have to give this IP to us. So you'll have to check which of these clauses you are signing, just to make sure that if you wish to do something on your own individually while you are still in the company, a lot of times employees come to us and say that they have invented something as part of the company and they don't know what to do about it because their company is objecting to them from starting their own company using such inventions or innovations and so on. Right? So you need to understand what kind of a clause you are signing and what are the consequences of signing such a clause.